Hi, my name is Lorenzo Azar Banks here on behalf of Minority Report Law Office here in Oklahoma City. And today I'm doing another video response to a question that we had posted to our Facebook page, and this is one of our more common questions that we get to answer at the office. The question goes something like this. Lorenzo, I had a job and I got great reviews and great employee evaluations, and I loved my job. I did it well. But all of a sudden, for some reason, my job let me go, and they didn't even give me a reason as to why they let me go. Doesn't my job have to give me some reason before they terminate me? No. Unfortunately, generally, in the state of Oklahoma, an employer does not have to let you know why they let you go before they let you go. Now, I know this can be disheartening, but let's get into the law so we understand it more. Oklahoma courts have adopted what we know as the at-will employee doctrine. The at-will employee doctrine essentially says this, that for employee-employer relationships that last for an indefinite duration, there is no ending that has been set. Those relationships are deemed to be terminable at will. That employee is considered an at-will employee, and the employer or the employee may end that relationship at any time without notice and without cause. Essentially, you are deemed an employee at will more than likely if this happens, or if these circumstances exist. If you have not signed a contract that lays out how long you are to work for this particular entity, or the terms as to how you are to be terminated, you are more than likely considered to be an employee at will, and that employer may terminate your position at any time without notice and without cause. Now, do not fret, because that would seem like, well, what's the point in working if anyone can let you go at any time? Well, there are exceptions. For every rule, there's an exception to the rule. One of the exceptions to this rule is the implied contract exception. An employer may not terminate even an at-will employee if it would violate an implied contract that exists in between the two. So this happens when an employee never signed any contract laying out the terms of his or her employment with an employer, but the actions of the employer would lead a reasonable employee to believe that his or her employment was to be governed by the terms of this implied contract. This oftentimes happens with oral assurances, things that were said during the interviewing process that would lead an employee to believe that they were going to be there long term, or that they were only going to be terminated for certain reasons. This also happens with written assurances, things that go back and forth. A very common occurrence are emails from higher management saying that you have a bright future at this company. We look forward to a long relationship with you at this company. These things may be considered an implied contract in between the employer and the employee. But also, written assurances can be found in the employee handbook. Oftentimes, companies and entities will have in their employee handbook that an employee will only be terminated for good cause. Now, if that exists in a handbook, this can be considered an implied contract, and an employer will not be able to terminate that at-will employee unless it is by the terms of the implied contract in between the two parties. More than likely, the employer is going to have a conspicuous disclaimer in that employee handbook that says that this handbook does not constitute a contract by any means. But know that absent that language, that handbook can be considered an employee contract, and that employer will not be able to terminate that at-will employee unless it is by the terms of that handbook. The other major exception is the public policy exception. An employer may not terminate an at-will employee if it would violate some major public policy. And this is such a vast and large exception to the at-will employee doctrine that it has so many subcategories. I'm going to flash them. I'm going to scroll them across the bottom of the screen because there are so many. It's this idea that we don't want to allow employers to penalize at-will employees with termination because the at-will employee did something that we believe as a society, we believe as the general public, is good for society or the public at large. It's this intricate balance in between an employer's right to effectively and efficiently run a business, the employee's right to earn a living and a livelihood, and society's right and interest in making sure that its public policies are carried out. So some things we want to take away from this video. We hear people say that, well, yes, I'm an employee at will, and my job doesn't have to give me any reason as to why they fire me before they fire me, but they have to at least have good reason as to why they fire me in HR files. No. See, what these people are talking about is something that we know as the implied covenant of good faith and fair dealing. This is something the courts say is an implicit part to every contractual relationship in between two or more parties. In other words, the parties will work fairly and in good faith with each other to make that agreement work. They'll do everything they can to make it stand, and the only reason they'll end the agreement is if it's for good cause. The problem is that only about 11 out of the 50 states apply this toward at-will employee situations, and Oklahoma's not one of the 11. In fact, in 1989, the Oklahoma Supreme Court explicitly came out and said that the implied covenant of good faith and fair dealing should not be applicable to at-will employee contracts and situations. So, essentially, the Oklahoma Supreme Court said that an employer doesn't even need good cause to terminate an at-will employee. We also want to take away from this video that if you feel like you've been terminated outside the parameters of your employee contract, or if you were an employee at will and you were terminated against one of the exceptions to the at-will employee doctrine, you need to contact an attorney immediately, because you may have an action against that particular employer for wrongful termination. And there are time limitations that you have to abide by in proceeding forward with those actions. In short, move quickly. Once again, my name is Lorenzo Azar Banks, here on behalf of Minority Report Law. You can reach us at minorityreportlaw.com, or you can catch us on our Facebook page at facebook.com/MRLawOffice. Post your questions there and like us so you can keep up with the videos that we're posting. So hey, most of us here in the United States are some type of employee. Now, for those of you living in Oklahoma, you know a little bit more of the particularized laws dealing with you and your employer. I hope this was informative, and hey, we'll see you next time.